Activity under Schedule 2. It is treated as service. Temporary transfer or permitting the use, or enjoyment of any intellectual property right. So the word temporary is where you important. So, which are the intellectual property rights? Like copyright, patent, trademark, etc. So if there is a temporary transfer, then it will be treated as service. So obviously, if it is a permanent transfer, that will be treated as goods. So transfer of copyrights. The copyrights have been given for next 5 years. Then it will be treated as service. But if you are transferring the copyrights permanently, then that will be treated as a sale of goods or supply of goods. Just remember these things. That temporary transfer of intellectual property is service. But permanent transfer will be treated as goods. Supply of goods. Next one. Development, design, programming, customization, adaptation, upgradation, or enhancement. Implementation of information technology software is treated as a service. So, if you are implementing a ERP software, you are upgrading that. If you are doing some kind of a modification in the design development part of that, and all these will be treated as supply service. But there is a very thin line of difference, that there is a difference between a software as a service and software as a sale of goods or supply of goods. Like, if a particular software is granted, and it is sold as such, then in some cases, it will be treated as supply of goods. Now this is not directly covered under GST, but based on various code cases, that any particular branded software, if you're selling, you're not giving the right to use. If you're giving the right to use, then it is again services. But if you're selling that particular as a product, then it will be treated as supply of goods. Agreeing to the obligation to refrain from an act or tolerance, an act, or a situation, or to do an act. This is treated as service. This is something in for consideration, you're agreeing for an obligation to refrain from an act. It means I agree. Okay, I will not do this, but maybe something for you tolerate, an act. But for consideration, or a situation, or you agree to do something for a consideration, then that will be treated as a service. See, for example, there is Mr. A, who said that, I will pay you ₹1 lakh rupees. But you don't participate in a tender. There are two competitors, A and B, and they're bidding for one tender. A come forwards, and he gives B an offer, that I will pay you ₹1 lakh. You don't participate in that tender. So obviously I will win the tender, I will do that business, right? So they're agreeing to the application to refrain from an act. B is refraining from acting, or he is not putting up his tender. And for that he is receiving the consideration. So this 1 lakh rupees received by A. Received advisory fee will also be treated as supply of services. This is very important. It is an indirect view on. Openly it is treated as a service. But for the purpose of GST it will be treated as supply of service. And on this 1 lakh rupees he has to pay GST. Next one is transfer of right to use any goods for any purpose. See, Mr. A allowed to his generator whenever needed to Mr. B. And for that he is charging him, based on per hour or per day, etc. So this allows to use a particular goods is treated as service. Transfer of the right to use any goods for any purpose. So like this, any machine, any equipment is allowed to be used. And for that you are charging any consideration that will be treated as supply of service, and not supply goods. Next is works contract is always treated as supply of service. What is the definition of works contract? Under Sec. 2(119), works contract means a contract for building, construction, fabrication, completion, erection, installation, fitting out, improvement, modification, repair, maintenance, renovation, alteration, or commissioning of any movable property, wherein transfer of property of goods, whether as goods or in some other form, is involved in the execution of such contracts. So let us try to understand the meaning of works contract for the purpose of GST. It is always treated as service. This definition we can divide and simplify as the essential elements. What are the essential elements of the definition? It is a contract for building, construction, fabrication, completion, erection, installation, fitting out, improvement, modifications, repairs, maintenance, renovation, alteration, or commissioning. So it is a contract or any of this, of what? Of any immovable property. The word is very important. So if you are doing a repair to any immovable property, it is treated as works contract. Renovation of a movable property, the renovation of your house, renovation of office, it is treated as works contract. Construction of a immovable property, it will be treated as a works contract. And in the execution of such contract, transfer of property in goods, whether as goods or in some other form, is invalid. Now this third condition is little bit tricky, trying to understand what are the example. Say you're painting a house. Okay, so the first two conditions are fulfilled. It is a contract for repairs and modifications and renovation. We can say a painting of a movable property houses is a movable property. So first two conditions are fulfilled. See the next third one. In execution of such contract, transfer of property in goods, whether as goods or in some other form, is involved. It means, while executing this contract of painting, whether there is a transfer of property in goods. Yes, see, for painting, you are using various different paints. These paints are goods, the property. They are transfer, whether as paint or in some other format. When they transfer, you cannot say that I have transferred the paint as paint. That paint is applied on the wall. So, they are transferred not as paint, but in some other form. But that's okay. So in execution of such contract, transfer of property in goods, whether as goods, or in some other format, is in word. So here, the transfer of property in paint has happened, but not in the form of paint. So, this will be treated as a works contract. Now check another, like repair software computer. Somebody comes for repairs of your computer and some parts have to be replaced, etc. So it is a contract for repairs, but it is a contract for immovable property or not? No, it is not an immovable property. So this repairs services of computer, machine, furniture, etc. This will not be considered as works contract. So just remember, the worst contract is applicable only for immovable properties. For mobile properties, it's not applicable. To what scheduled to says is works contract will always be treated as service. So painting of house, repair, renovation, building, construction, fabrication, erection, installation of a movable property, all these contracts will be treated as supply of service, not supply of goods. This is also an important concept. Composite supply of food, or any other article for human consumption, or any drink, other than alcoholic liquor, or human consumption. It is kept aside because on this GST is not applicable. So accept this, if there is a composite supply. For the time being, let us don't discuss the meaning of composite supply. We are going to discuss that in a separate chapter altogether. But simply composite supply means, where supply consists of two or more goods and services. Simply, it's not an accurate definition. Just to understand. So it is a composite supply, it is a mixture of two or three supplies of what? Food or any other article for human consumption or a drink. then it will be treated as service. It's a little bit tricky to understand. When you go in a restaurant, what is supplied to you when you order food for human consumption or any drink? It is supply of service, as well as goods. You go and you order one lunch. Now he is supplying, that particular restaurant owner is supplying you goods. There is no question in that. But what about service? There is a special assistants are there, waiters are there who are serving you the food, so there is a supply of service also. So this is a composite supply. Combination of supply and supply of goods, as well as service. This will be treated as supply of services, not of goods. So whenever there is a composite supply of food, drink, any article for human consumption, means the supply of goods is also there and supply of service also there. Then it will be treated as supply service. But just imagine that in one retail shop, you are just purchasing one bottle of cold drink. Whether that is supply of goods plus supply of service. No, it is a simple sale transaction. Across the counter, you pay him the cash, he gives you that particular bottle of cold drink. So there is no involvement of supply of service, it is not a composite supply. So that will be treated as supply of goods. You purchase one biscuit, you purchase one cold drink to purchase one ice cream. Across the counter. There is nobody who is serving you, there is no service element involved, there is no composite supply. So, that will be treated as an independent supply of goods. But, in such cases like restaurants, or if the caterer is providing you the service, he is providing the food, as well as service, then that will be treated as a composite supply and taxable as supply of service. Lastly, supply of goods by an incorporated association or body of persons to a member thereof, will be treated as supply of goods. There is association of person or a club, and it is providing some goods to its member. There is a consumer association, and that is supplying goods to its members. So all these members who are receiving goods are actually created as supply of goods. This is quite logical. So in a club, in a gym, you are a member of a club or gymnasium, or any particular association, and there is a good together. And in that they are supplying you some kind of goods, they are selling some kind of goods, then that will be treated as supply of goods.